The property manager called Maria on a Tuesday afternoon to let her know her tenant had moved out. Not that the tenant had given notice, that had happened 3 weeks earlier. Not that the unit needed work, it clearly did. Just that, by the way, your property is now vacant and will get started on turnover soon. Maria owns a fourplex in Fresno. She was paying that management company 10% of gross rents every single month. For that Tuesday afternoon phone call delivered 3 weeks late, she fired them the next day, and she is not alone. Across California, independent landlords are terminating property management contracts at a rate that the industry hasn't seen in years. Not because landlords suddenly love paperwork, but because the math stopped working, the service stopped delivering, and the tools available to self-managing landlords got dramatically better. If you're currently writing a check to a property manager every month or thinking about hiring one, you need to hear this before you make a decision you'll spend years paying for. Every property manager in California will tell you their fee is somewhere between 8% and 12% of monthly rent. That sounds manageable. On a $2,000 unit, that's $160 to $240 a month. Fine, except that number is a fiction. Here's what the actual bill looks like. Leasing fees, typically half a month to a full month's rent every time a tenant turns over. Maintenance markups. Most management companies add 10% to 20% on top of every contractor invoice, sometimes more, and they don't always disclose this clearly. Vacancy fees, inspection fees, lease renewal fees, sometimes even a monthly administrative fee on top of the percentage. When you add it all together, independent landlords in California are routinely paying 20% to 25% of gross annual rent to property managers when you account for all the ancillary charges. Take a duplex in Sacramento with 2 units renting at $1,800 each. That's $43,200 per year in gross rent. At 10% management, you're at $4,320. Add 1 leasing fee per unit per year, another $3,600. Add maintenance markups across the year, conservatively $800. You're at $8,720. That's over 20% of your gross revenue. Gone. Before your mortgage, before your taxes, before your insurance. Now here's where it gets interesting. That same duplex, self-managed with modern software tools, might cost you $50 a month in technology and 3 to 4 hours of your time per month once the tenants are stable. The math is not subtle. You are not paying for convenience. You are paying for the feeling of convenience, and increasingly landlords are realizing those are very different things. Let's talk about what you're actually buying. The core promise of a property manager is that they handle tenant communication, maintenance coordination, rent collection, and leasing. In theory, that's valuable. In practice, the experience looks a lot more like Maria's Tuesday phone call. Here's a story that illustrates the structural problem. A landlord named David owned 3 single-family rentals in the Inland Empire. He hired a management company that came recommended, had good reviews, professional website. For the first year, things seemed fine. Then his tenant in one property started complaining about a slow drain. David didn't hear about it because the management company was handling it, except they weren't. The drain became a backup. The backup became water damage in the cabinet below. The water damage became mold. By the time David found out, because his tenant called him directly, not the management company, he was looking at an insurance claim and a 2-month vacancy. The management company's response? They said the tenant hadn't reported it urgently enough. No accountability, no refund of fees, just a contractor referral with a markup. This is the fundamental misalignment of incentives in property management. A management company's revenue is relatively stable whether your property performs well or poorly. They get paid on occupied units. They get paid on turnovers. They get paid on maintenance. There is no financial penalty for letting a small problem become a large one. Your financial pain is, structurally, their revenue opportunity. And California law doesn't protect you here the way you might think. Your property management agreement almost certainly has an indemnification clause that shields the company from liability for most of these failures. You signed it. You probably didn't read page 4. But wait, there's a catch to the self-management story. And it's the reason landlords kept hiring property managers even when they suspected the value wasn't there. Self-management used to be genuinely hard. Tracking rent payments across multiple units meant spreadsheets. Maintenance requests came in at midnight via text to your personal cell phone. Lease renewals required manually drafting documents. Screening tenants required calling references and deciphering credit reports. That was the real world 3 years ago. It is not the real world now. Rent collection is now automated through platforms that handle ACH transfers, send late notices automatically, and log every payment. Tenant communication can be routed through dedicated portals that keep your personal number private and create a documented record of every exchange, which matters enormously when you're in front of a California judge. Maintenance requests get triaged digitally, with the tenant uploading photos and you approving or declining work orders from your phone. AI-assisted lease drafting tools mean a California-compliant lease is no longer a 3-hour project. The landlord who self-manages 5 units in 2026 is not the landlord who self-manages 5 units in 2018. The operational burden has dropped dramatically. What used to require a professional intermediary can now be handled by a reasonably organized person with the right software stack in a few hours a week. The property management industry built its value proposition on information asymmetry and operational complexity. Both of those advantages are eroding fast. Here's a question worth sitting with. If you fired your property manager tomorrow, what would actually get worse? Compliance is the honest answer. California has some of the most landlord-hostile regulatory environments in the country, and it's getting stricter. AB 1482 limits rent increases to 5% plus local CPI for most properties built before 2005. Just cause eviction protections apply statewide after 12 months of tenancy. Security deposit law changed in 2024. You can no longer hold more than 1 month's rent as deposit on unfurnished units. Local rent control in cities like Los Angeles, San Francisco, Oakland, and San Jose layers additional requirements on top of state law. The assumption is that a property manager handles all of this for you. But here's what a landlord named Patricia found out the hard way in Oakland. Her management company served a rent increase notice that exceeded the local rent stabilization ordinance cap. The company had used a template that hadn't been updated for the current year's allowable increase. The tenant filed a complaint. Patricia, as the property owner, was the legally liable party, not the management company. She paid the penalty. She paid the tenant's attorney fees. Your property manager is not your lawyer, and their errors are your liability. The compliance risk doesn't disappear when you hand over management. It just gets laundered through a third party until it becomes your problem anyway. If you self-manage, you're forced to know the rules. That knowledge is protective. Ignorance outsourced to a management company isn't protection. It's deferral with a monthly fee attached. If you're considering firing your property manager, or you're on the fence, the transition is more manageable than it feels. The landlords who do this badly treat it like a single event. The ones who do it well treat it like a project with a timeline. Start with your existing leases and tenant files. You are legally entitled to all of this documentation. Request it in writing by certified mail if necessary. Your management agreement should specify the transition timeline. Typically 30 to 60 days notice is required. Do not let them slow walk the file transfer. Those records are yours. Talk to your tenants directly before the transition is complete. The simple professional letter explaining that you'll be managing directly, providing your contact information, and the new rent payment process goes a long way toward keeping good tenants comfortable. People resist uncertainty. You're removing uncertainty. Set up your operational tools before your first day of self-management, not after. Automated rent collection, a maintenance request system, and a secure document storage solution are non-negotiable. These are not expensive. The combined cost is a fraction of 1 month of management fees. And be honest with yourself about your portfolio size and your time. If you have 20 units across 4 cities and you work a demanding full-time job, full self-management may not be realistic. But if you have 4 to 8 units within a reasonable geographic radius and some capacity in your schedule, the calculus almost certainly favors self-management in 2026. The landlords who are firing their property managers aren't doing it out of frustration alone. They're doing it because they ran the numbers, looked at what they were actually getting, and decided the gap between cost and value was no longer acceptable. Recap, here's what to take away. Property management fees are not 10%. They're closer to 20% to 25% of gross revenue when you account for all the hidden charges. The incentive structure of a management company is not aligned with your financial outcomes. California compliance liability stays with you as the property owner, regardless of who manages the property. Technology has dramatically reduced the operational burden of self-management, and the transition is a project, not an event. Plan it deliberately, and you'll execute it cleanly. Maria's fourplex is fully occupied today. She manages it herself, spends about 5 hours a month on it, and pockets the $9,000 a year she used to send to a company that called her 3 weeks late on a Tuesday. That's not a unique outcome. That's what happens when the math finally becomes undeniable, powered by LeaseBase intelligence.